A very good afternoon. You're watching NDTV 24/7. I'm Divya Vadva. Let's get you our top story. Backing the Enforcement Directorate with a crucial judgment, the Supreme Court today rejected almost all objections that were raised against the probe agency's powers. The top court has upheld all the stringent provisions of the PMLA in proceeds of the crime, as well as search and seizure, the power to arrest, attachment of properties and bail, which were under the challenge in the court. We have my colleague Sukirti joining us. Sukirti, take us through the proceedings in court today of the Enforcement Directorate now continuing to have all the powers that they did. Almost all their pleas have been rejected. On what grounds were those pleas rejected?
Well, yes, so this is definitely a big victory for the central government at this point of time, because all the powers that the Enforcement Directorate gets in terms of taking action under the provisions of PMLA, all of those powers have been upheld by the Supreme Court. As far as the arguments earlier in court were concerned, based on which Justice A.M. Khanvilkar today read out this verdict, the arguments were about various issues, the special powers of arrest that the ED has, the burden of proof is on the accused in the cases that are filed under PMLA. The ECIR copy is not mandatory. That is what the Supreme Court said today. So as far as the grounds that were dictated by the Supreme Court today are concerned, it said that the powers of arrest are not arbitrary. The kind of special powers of arrest that the ED has, those are justified. They can continue to do that. The ECIR copy, that's not something that the ED has to provide mandatorily, because it is not similar to an FIR. The ECIR is an internal document. ED is not supposed to give it to the accused, and various other provisions which were pertaining to how the statements that are given during the investigation in the ED cases, those are admissible as evidence, which is contrary to how usual legal cases are, where if you have been giving a statement under or in the during the investigation process, that is not admissible in the court of law, because the authorities may have coerced you to give those statements. That is the general rule that is followed in usual cases, but in the PMLA cases, those statements during investigation, those are considered as evidence. So even that power, that provision of the PMLA has been upheld. So a big victory for the central government, which had been represented by Solicitor General Tushar Mehta during the course of the proceedings in court, where he had said that even in cases of fugitives like Vijay Mallya, Nirav Modi, Mehul Choksi, because of these PMLA provisions, we've been able to attach assets worth 18,000 crore rupees because of these strict provisions. And also, it's not just for fugitives where PMLA provisions are helpful, but also in cases of terror funding, where we are able to track the money trail, we are able to attach assets that were used in funding terrorism activities. In all of those cases as well, PMLA is extremely essential. So a big victory for the central government today, and a defeat for opposition leaders, including Karti Chidambaram as well as Anil Deshmukh, who had filed petitions challenging these provisions.
Right, we've seen quite a surge as far as these money laundering cases are concerned. If you can just take us through some of the statistics as to the kind of rise that we're seeing in these cases.
Well, yes, definitely there has been a big rise in all of these cases. If you look at, the high-profile cases that we've just been seeing in terms of, Sonia Gandhi being questioned or Partha Charji, TMC being questioned, but also money laundering searches in the last 8 years, if they are looked at, only 23 have been convicted. 112 searches have taken place between 2004 to 2014. Proceeds of crime worth at least over 5,000 crore rupees have been attached in this period. 888 prosecution complaints have been filed under the Modi government's rule. 104 of these have been filed between 2004 to 2014. So all of this data has in fact been given by the Finance Ministry in the Parliament as well, where they've said that we are taking strict action on all cases of money laundering, and that has been one of the reasons why even in bigger cases like those of Vijay Mallya and Nirav Modi, the central government has gone out of its way to provide statistics at repeated points of time, saying that this is the action we are taking, this is the proceeds of crime that has been attached so far. That's the same kind of strategy they adopted in the top court as well. And going by the verdict that has come out today, it seems that the central government has managed to convince the top court of the country that it has been taking the right kind of action when it comes to money laundering cases, and that is why it deserves to retain all of these powers that the Enforcement Directorate has, including special powers of arrest, as well as taking statements during investigation as admissible evidence.
Right, Suketi, thank you so much for joining us. In fact, to get more on this, we have Kapil Madan, advocate of the Supreme Court, joining us, as well as Aashutoshsrivastava, advocate of the Supreme Court, with us as well. To begin with, the Supreme Court today has rejected almost all objections that were raised against the probe agency regarding several powers that include initiation of the investigation, also the power to arrest. Now, the demand was to change the law, but on what grounds did the Supreme Court today deny the litigation plea? If I could take this question first to Aashutoshsrivastava.
See, the Supreme Court heard both the parties at length and in details, and it also examined the provisions of law, including like Section 50 of PMLA or Section 45 of PMLA and other provisions of law, including Criminal Procedure Code. And the Supreme Court, after hearing in details and with the supportive documentations, it was of the view that ED has got certain powers which have been conferred upon it by the PMLA 2002, that is Prevention of Money Laundering Act. And accordingly, they have the power under Section 50 to investigate the matter or to summon any accused, or to further under Section 5 to attach the properties provisionally. And after that, obviously the courts are there to look after whether the attachment is right, wrong, whether that attachment has been done unlawfully. There are courts to look after all those aspects. So it is not that the ED has got that kind of unlimited powers. They are being supervised by the courts in further actions by them.
We've seen a huge surge in cases up until recently. What we are seeing is that the number of cases have gone up considerably, so over 5,000 cases as far as money laundering is concerned, and that is what we are seeing in the last 10 years. But the conviction rate is very, very low. Only 23 people have been accused so far. Also, as far as the Modi government is concerned, we are seeing that the money laundering raids are up by almost 26 times.
Yes. See, first of all, this act was enacted in the year 2002, not now. And this is, there was no such any demand of change or anything since then. Now, if we see at present, yes, the conviction rate is low. That is what is the data showing. Obviously, it takes long time for the prosecution to establish the case, and in many cases, it gets dragged for years together. Now, it is also expected from the Enforcement Directorate that while doing so, or they should.
If we just get you an account of the number of cases that were filed in 2018 to 2019, they amount to about 195 cases. But what we are seeing in the last 1 year, almost 1,200 cases have been filed.
Yes, so ED is expected to utilize its powers judiciously, and it should see prima facie what kind of case is made out against any accused or any company, and while doing so, how concrete evidences they have in their hands to accuse anybody, so that the conviction rates go up, and only the people the accused who are really guilty of committing any offense are prosecuted under this provision. So obviously that is expected, but the Supreme Court is of the view that is what is required to be done. But at the same time, their rights or the powers given to them by the PMLA cannot be snatched away from the ED, and they have the powers to investigate the case in the interest of justice, and they can arrest a person. And obviously, a person who is apprehending the arrest can also approach for the bail, and they can fulfill the two conditions as prescribed in Section 45 of PMLA, where the opportunity can be given to the public prosecutor to object the bail, and if the court is satisfied that the person who has been accused is not guilty prima facie to have committed any offense like that, can be given bail by the court. So
right.
That
Let me just get Kapil Madan in as well. Kapil, the petitioners had argued that unchecked power to arrest the accused without informing them of the grounds of arrest or as evidence is unconstitutional, and of course the opposition has gone on to say that the ED has become a tool that the government seems to be using.
So Divyaji, I would say unequivocally that this would be a very, very critical judgment, and one of my friends here mentioned that the person who has been caught by the ED, arrested by the can approach and take a bail. Let me now bring you to the most important and the most crucial part of this case. Now, you may recall, Divya, in Nikesh Tarachand's case, the Honorable Supreme Court had struck down the twin condition that is there in the PMLA Act, which you need to satisfy before you are granted bail. Now what has happened? In contrast to what was said in the earlier judgment of Nikesh Tarachand, this particular judgment has upheld the validity of those twin conditions. Now, if you are arrested, you need to now show to the court that there is no prima facie case against you and you are not likely to commit any offense while being on bail. Now, understand the problem here. Now, ECIR, the Supreme Court in this judgment has said that the ECIR is not the FIR and you will not be given the copy. Now, you will be in a situation where you are arrested by the ED. The ED can refuse to give you the copy of the ECIR. How are you likely to show to the court that there is no sufficient evidence, no prima facie evidence that would show that you have not committed the offense or you have committed the offense? Now, to my understanding, I think this judgment will create a lot of problems, because ultimately the bail jurisdiction, we are not a police state. Bail is a rule and jail is the exception. This judgment is in contrast with the judgment given by the Supreme Court in Nikesh Tarachand's case, wherein while striking down these two conditions, the conditions of the PMLA Act, the Honorable Supreme Court has already said that these conditions violate the fundamental right as enriched under Article 21 of the Constitution of India. So to my understanding, I think, I mean, this judgment, to me, it appears to be very, very critical. And given the fact that PMLA is now being frequently used as a political tool where cases are being filed, no trials have concluded. The data suggests that there is only 0.5% conviction of the total number of cases that are being registered. So I think this will give unfettered, unchecked powers to the ED, and there is a very, very high chance that, now ED will have a greater level playing field for its abuse.
Right, actually quite a crucial judgment there, with the Supreme Court upholding the powers of the Enforcement Directorate to arrest, search and seize, and saying that those powers are not arbitrary, and arrest made in money laundering is not arbitrary, is the big ruling that's come out by the Supreme Court today. Thank you so much, gentlemen, for joining us here on NDTV this afternoon. With that, we're slipping to a very short break. News and updates will continue on the other side. Stay with us.